Our next case on the list today that we will consider is 24-1657 in the matter of the estate of Eugene F. Bachman. Mr. Wonio, you are here for the contestants, and Mr. Collins, you are here today for the proponents of the will, as I understand. Okay? All right, thank you. And anytime you're ready, Mr. Wonio.
Thank you, Your Honors. May it please the court and counsel, always an honor to present up here and a privilege to represent Iowa citizens in resolving their disputes, and always fun to get some banter with the Court of Appeals. I will avoid my sports analogies this time, Judge Allers. That didn't go well for me last time. And I don't mean to make light of it. Everything here is serious and a very, very hard-working court, so some levity I always find is helpful. We're here about Mr. Eugene Bachman's legacy. Mr. Eugene Bachman started from scratch a tool and die company that became wildly successful. And in the later stages of his life, he had a dramatic departure in how he was going to treat all of his children relative to that legacy. A legacy should not be a committee approach. And in this case, the committee approach is what I think the district court overlooked in resolving the factual disputes, and in specific, didn't even curbside the evidence that was presented relative to the issues before it. I will start, there are a couple of procedural or jurisdictional issues, and I want to just touch on those very briefly. If the court has questions, I know they'll ask. The first question is relative to standing. I think that's a very simple answer, and the district court did get that correct. Parties that have their rights potentially impacted by, and particularly as it pertains to a probate proceeding, they are listed in the estate planning documents, but if you talk about the related and referred to documents, their rights are impacted by how that's decided, so I think decidedly they have standing. There was a question raised in some of the briefing about whether or not certain or specific issues were raised before the district court. I believe that's also a red herring. I believe the citation was to the minor case, and the suggestion that maybe we didn't raise certain claims about Mr. Leon Bachman and statements he made, and also a claim that we didn't raise expert witness issue with the district court is somehow dispositive of our ability to appeal. We disagree. The minor case contemplated the injection or lack of injection of an immunity statute in the case. And the law, I think, is very clear. Appellate courts are not and are beyond reluctant to address issues a district court has not evaluated and come to a conclusion on. None of that is present in this case. Everything being appealed was evaluated, referenced, and decided by the district court. So it's not similar to minor, where the district court did not have an opportunity to evaluate that matter. The final one is the timeliness. I will admit it's a somewhat interesting approach from my opponent. The probate court, and in cases like this that are conceitedly kind of a hybrid, we get a jury trial and probate court proceeding. It's a little bit different than if you're filing an action for money owed to you or something else in the probate, where there are certainly motivations to get things resolved. We know there are shortened timelines in the probate court for contesting wills, for example, because courts want to get those wrapped up. The difference and the distinction here is this is the action. So we bring the action. All of the players and the issues in that action remained after the first summary judgment motion.
Around the language in Iowa Code section 633.36 that says, all orders and decrees of the court sitting in probate are final decrees as to the parties having notice and those who have appeared without notice. Why wouldn't that April 30 summary judgment ruling fit into the category of all orders, and clearly the parties had notice, right? So, I mean, there's no dispute there.
Oh, sure, I wouldn't dispute the notice issue, of course. Again, I think it's different in the sense the Iowa appellate rules and the spirit of those rules that I know we've cited contemplate if you keep the parties, and I believe it's a Vallis v. Muting case that was cited in the materials. In that case, there was a probate proceeding because it was a death and there was a wrongful death action. And some of the defendants settled, some got out on summary judgment. And the majority opinion was very clear. There remain parties, there remain issues to be resolved. And in that case, they were even severable. We know the case law doesn't demand them to be severable, but the Supreme Court said this is an interlocutory appeal of those summary judgments.
Was that a lawsuit that involved an estate, or was that actually an estate proceeding?
It was a lawsuit that involved an estate,
Because then it doesn't fall under 633.36 because it's not a probate order.
Theoretically, I don't see it that way. The way I see it is it fits into, and what the majority said in that Muting case was, in addition to the fact that we have remaining parties and people, although severable, we want to keep this consistent with the idea that we're not going to go through piecemeal appeals. And I think that's important.
But the April 30th order dismissed all of your claims, right?
It did not dispose of all of the claims between the parties, no.
Not my question. Okay, I understand. I understand it didn't address the counterclaim in the interiorum clause, but it did dismiss all the claims that you made, that you were making, all causes of action that you were asserting. Correct?
Sure. Of course, I'd have to concede that. I don't think that's dispositive of the issue, and to the extent then we would render the rules of appellate procedure, moot. I don't think that's the goal of the law either.
The rules of appellate procedure say that you have the right to appeal from all final orders, right? And then the Iowa Code section says that all orders and decrees of the court sitting in probate are final decrees. So it's giving the statutory stamp of finality to it, which then you go to the appellate rule, says it's appealable as a matter of right. And even to the extent that there's differences in the rules of appellate procedure that conflict with 633.36, why wouldn't the specificity of 633.36 trump the generality of the Iowa rules of appellate procedure?
I think the unfairness that you're applying to your analysis, Your Honor, is the total drive-by of the express language of the rules of appellate procedure, as well as the long-standing statements from our Supreme Court and this court that we're not going to do piecemeal appeals. And I think the rules of appellate procedure don't simply say you have a right to an appeal. They outline this exact situation where you have a partial resolution of causes of action against litigants. You have an option to choose either an interlocutory appeal at that time, or you get from the later of, when all the issues are disposed of. I think that's very specific, and that specifically contemplates exactly what we had in this case.
Thank you.
In your no contest section, at summary judgment, it's put up or shut up. And so from the standpoint of the evidence that the court could evaluate as to whether or not this was a good faith claim, what evidence was there other than, we suspect things?
Well, of course we have the we suspect things, and it's not unsubstantial. I think there's quite a bit of that, and we know in these types of cases, and we cited some law, that hearsay in the setting of whether or not a person acted in good faith certainly is not wholesale excluded, as the district court suggested, but we had a lot of personal and anecdotal evidence that was in the record about interactions the kids had with their father and with each other that are not without merit. The medical records themselves, of course, supported that. What's that?
Are they in the record?
Sure.
Where are they?
In the appendix, I don't have that off the top, but there were, I know, let me just think of one document.
Anymore, so we can't go there. But is it attached somewhere in the pleadings to some filing in the pleadings docket?
I know for certain we have them attached to our resistance to motion for summary judgment. I can think in particular The Dr. Bender 2016 evaluation, this was before the litigation, of course, but it identifies, for example, in there that there was a long-standing neurological decline, and then, of course, the diagnosis. Well, all of that would play into whether or not they acted in good faith. And I, of course, take pretty significant umbrage to the idea that the court relied on the contrary or contradictory affidavit rule. One of the affidavits, they were never even asked in their deposition, so there was nothing to contradict. So that one should not have been ignored. But as importantly, the two that were discarded by the district court, the testimony was, yeah, we had these discussions, she couldn't remember with whom and where at the time. That's not the same as saying, I didn't have a discussion and we didn't discuss this and that and the other. So I think that's a distinction. Would like to reserve some time for rebuttal.
Mr. Collins?
May it please the court, counsel. The plaintiffs did not timely appeal the April 30, 2024 order dismissing their claims. As Judge Allers has indicated, Iowa Code Section 633.36 provides all orders of a court sitting in probate are final decrees as to the parties with notice and those who have appeared without notice. The appeal deadline in this case on the first summary judgment was on May 30th, 2024. The appeal in this case was filed in October of 2024, 6 or 7 months later.
Oh, counsel, if we have a situation where, for lack of better terminology, plaintiffs file a lawsuit, defendants file a counterclaim, typically even if a summary judgment is granted to the defendant to kick out and dismiss the plaintiff's causes of action, with that counterclaim still looming out there, that summary judgment ruling would be interlocutory. Would that be the general rule outside the context of probate? Sure. Okay. And so by virtue of it being a probate proceeding, it changes that? Is that the position?
That's the statute. And the fact that the counterclaim on the interim's claim remained does not invalidate or make 633.36 inapplicable. The case, the primary case that was relied upon by the appellants was the Troster case, and the Supreme Court said in Troster that the district court ruling in that case was akin to a procedural ruling in a civil case. In Troster, the Supreme Court acknowledged that the district court did not decide the issues in the action. In other words, it was a procedural ruling. In this case, Judge Besler's order was a substantive decision which resolved all of the claims that were asserted, and it denied all of the plaintiff's requested relief. The other cases that are cited by the appellants are inapplicable because they are not probate cases. And in fact, this case is more closely aligned, if not directly aligned, with the Clegg decision, which this court issued in May, I believe it was May or March of May of 2024. In that case, as well as in this case, the plaintiff's complaints are based on an April 30th, 2024 order. The plaintiffs never moved to enlarge, amend, or appeal the order, and therefore this court determined that it lacked jurisdiction in Clegg, just as the court in this case lacks jurisdiction. They simply missed the deadline. The reliance on...
To in your brief? Is that case you're referring to in your brief? Yes, sir. Okay, and tell me the name of it again.
Clegg, C-L-E-G, 8 Northwest 3rd, 189, a 2024 decision of this Court of Appeals. Judge Cicchelli authored the opinion. The reliance on Iowa Rule of Civil Procedure 6.101 is misplaced. Iowa Code Section 4.7 provides if a general provision conflicts with a special or local provision, you try to construe to give effect to both. However, if the conflict is irreconcilable, the special or local provision prevails. And as Judge Allers observed, 633.36 is a special provision, and therefore it prevails, and therefore this court lacks jurisdiction and authority to address the appeal. I'd like to next address the interims clause, and start with reminding the court that a will is presumed to be valid, and courts should be reluctant to interfere with the testator's wishes. Plaintiffs in this case knowingly triggered the interims clause by filing this lawsuit. The plaintiffs lacked probable cause and good faith. This was demonstrated in the record below. The plaintiffs had the burden to prove they acted with good faith and probable cause, and they failed. There was no diligence undertaken by the plaintiffs before they filed this lawsuit. They make some generalized reference to medical records, which far post-date the time of the signing of the will, and they have referred this court to nothing that suggests that at the time this will was executed, that Gene Bachman lacked testamentary capacity. These plaintiffs did not interview Gene's lawyers. They did not interview Gene's medical providers, although they retained one of them as an expert in the case. They did not interview him before filing this lawsuit. Karen Bachman filed a lawsuit claiming that her father, Gene, lacked testamentary capacity in March of 2015, even though beginning 7 months after the execution of that will, she accepted $82,500 in cash gifts from her father, and then culminating 18 months after the will was signed in accepting a $200,000 gift of a house here in Des Moines from her father. And she said, well, of course he had testamentary capacity 18 months after he signed the will to give me those gifts and give me that house. But he lacked capacity when he signed his will 18 months earlier. Jeannie, one of the plaintiffs, admitted she had no evidence that Gene Bachman lacked testamentary capacity when he signed the will. Jeannie admitted she had no firsthand information that Gene was subject to undue influence, and in fact, she admitted she had no information he was subject to she had no secondhand information that he was subject to undue influence.
Read contestants' pleadings. This is more of a undue influence kind of situation. They're saying things are done in secret, against our father's wishes, and people were involved in the estate planning approach that shouldn't have been involved in it. So it's kind of that way. So address that.
Well, first of all, the plaintiffs failed to preserve that for review by this court. Second of all, the undue influence was dismissed because of lack of any testimony about the financial aspects on causation. The plaintiffs had none. The testimony from the accountant was that there was a 15 or more year old formula for calculating the value of this business. Gene Bachman, since 1991, for 24 years, he planned to he planned to sell this company to his son through the estate. And the accountant that worked with him came up with a formula with Gene, and that was updated every year to bring, based on the performance of the company in prior years. And that was done. They came up with the value using that methodology, and that's how this transaction was consummated. There was no gift to Leon. Leon bought this company, and he paid millions to his father between 2015 and the time of his father's death. The plaintiffs had no information, no basis, and in fact, each of them testified they had no basis to argue about the valuation. And I think the court needs to remember that undue influence needs to be clearly established. And according to Judge Besler, there was little more than speculation, conjecture, assumption, and family gossip. And that does not rise to the level, Your Honors, of clearly establishing undue influence. Getting back to the probable cause issue on the interims clause, Diane admitted she had no evidence that the will and the purchase agreement did not represent her father's wishes. She could not identify a single provision in the will that she believed resulted from undue influence. Attorneys Gary Strite and David Riley both represented Gene Bachman in this transaction. They both testified that Gene knew exactly what he was doing. Dr. Jacoby, a neurologist, reviewed medical records, and he expressed the opinion that Gene Bachman possessed testamentary capacity at the time of executing this will. Now, the plaintiffs want to argue, well, no, wait, but Dr. Bender in 2016 said, and then later said. But the fact of the matter is, Dr. Bender did not and could not say that in March of 2015, Gene Bachman lacked testamentary capacity. And what he did say failed to meet the standard. He said something about he was subject to possibly making unwise decisions, which is not the standard. The plaintiffs filed this lawsuit hoping to find some evidence, and that demonstrates they didn't have probable cause. The advice of counsel defense also fails in this case. They did not demonstrate that they made a full and fair disclosure. Again, none of the plaintiffs were able to testify that they advised counsel that Karen got $82,500 in cash starting 7 months after Gene's execution of the will, or that she received the $200,000 house. So there was no full and fair disclosure, and these contradictory affidavits that were submitted after the motion for summary judgment was filed, which is inconsistent with their testimony, are not to be considered. First of all, they didn't preserve the issue, and second of all, it violates the contradictory affidavit rule, and they failed to preserve error.
Is up, and Mr. Wonio, you do get rebuttal.
Thank you, Your Honors. I'll start with where Mr. Collins left off and the suggestion that we did not preserve error on the contradictory affidavit rule is a perfect example of how error was preserved on all issues in this case. Those affidavits were submitted as part of the motion for summary judgment. That issue was raised. It was considered by the district court, and the district court made a ruling on it. We disagree with the ruling, but decidedly the district court addressed that issue, and that's squarely before the court. We think that's exemplary of all the issues that were, yes.
That your filing of the action triggered the no contest rule or provision of the will?
You know, I'm pretty much in line with the Supreme Court in that these interiorum clauses are really an antiquated part of probate law. And so I'm not going to concede that it triggered it because in large measure, we had these discussions as laid out in the affidavits. My co-counsel, Tyler Smith, and I have created a niche practice in evaluating these cases, and we had these discussions with the clients. There was a disclosure, and we went through our list of, well, here's the red flags. Back to your earlier point, undue influence is one of the predominant themes in this case, and you're not going to have generally an email or an admission that, oh yeah, we tricked somebody or we unduly influenced somebody. This, as our appellate courts have indicated in rulings longstanding, that this is what's conducted in the cover of darkness. And
Don't we have evidence that's lacking here that whoever the undue influencer is takes dad to the doctor's office all the time, won't even let dad go to the doctor without him, or he basically, a lot of times you got situations where they've kind of segregated the testator, the undue influencer has, and kind of insulated him from the rest of the family members, or constantly knows in the financial situation, like dad can't go to the bank without him tagging along, type of thing. And we don't have any of that here, do we? And I'm not saying you have to have that, but I'm just saying those are kind of typical symptoms that we see of undue influence, right?
yeah, I go through my list of what are red flags and what are signs of undue influence. And candidly, lawyers that practice in probate law and they go to their CLEs train on these things. What's on the list? And some of those things, that's true, but I think some of them are here. I mean, if you look at Gary Strite, who's a lawyer in Cedar Rapids that I've got a tremendous amount of respect for, was head of the probate division. I've used him as an expert witness in some of these cases before. He admitted he didn't have any of the conversations with Mr. Eugene Bachman. He admitted that's unheard of in his practice, and he laid out what his process is. The fact that he didn't follow his own process is certainly evidence of undue influence. I'm not saying it's dispositive, but again, that's one piece of circumstantial evidence in this whole cog You know, they can't even identify which lawyer at this meeting is representing whom. Mr. Riley, who claims he represented, and I think, are you trying to ask a question?
I have a question. You know me too well. Well, I was going to ask you how you get around the gifts to your clients.
I don't need to get around it. I mean, is it a piece of evidence considered? Sure, but again, I think that favors what we're talking about. The court's weighing this evidence and saying, oh, well, this is good. Or, best example, Mr. Riley has all of these statements that are either contradicted in different portions of his sworn testimony, contradicted by other witnesses that were there, and the court just says, I mean, the most alarming conclusion in the summary judgment for me is he says, well, the attorneys and the accountant were there. Well, first off, the attorneys weren't both there, but secondly, so what? So what if they're there? That, when we have all these contradictions.
Problem for you that the party that's claiming that dad was unduly influenced and didn't have capacity, so she files a lawsuit making those claims, and yet after the time he executed the will, she's taking substantial gifts from him. And especially, it takes a higher level of capacity, I think, to give a gift of real estate than it does to execute a will. You agree with that?
In this case, I absolutely, totally disagree with that.
But if that's the case, but even if they're the same, if it's the same capacity, how do you get around? Isn't that a pretty good indication of the lack of good faith of this thing, that you're claiming dad was unduly influenced by brother and he didn't have capacity, yet he did have capacity and wasn't unduly influenced when he was giving me stuff?
Sounds like a great argument that should be presented to the jury from their side. I mean, the truth is, if you're going to compare the complex transaction that took place that we contest to a gift of cash, there's no question. And Attorney Riley, in his own notes, indicated, how on earth is Eugene going to understand the complexity of this transaction in this document? So I just think we're talking apples and oranges, but again, I think that's an argument to be made and in favor of the reason we should be able to present the entirety of this circumstance to the jury. And thank you.
Wonio and Mr. Collins for the excellent arguments today and the great briefing. We will take this matter 24-1657 in the matter of the estate of Eugene Bachman under consideration, and my colleagues and I will issue a decision as soon as we can. Thank you.